Ms. Landers, this is what's called an initial appearance. I'm going to go over some information with you. I'm going to talk to you about your bond, talk to you about the conditions of your bond, I'll go through your charge. I'll give you a lot of information. You'll get a piece of paper when I'm done. It's got all this stuff written down on it, so you don't have to memorize what I'm telling you. You've got a great lawyer out there who's going to represent you here, and he can also answer any questions you may have. I'm going to start by telling you have the right to remain silent. Anything you say can and will be used against you. To the extent today, you don't even have to speak to me. If you're not happy with the bond amount, you're not happy with the conditions of your bond, then you can talk to your lawyer, who will talk to the court, and then we can address those issues at that point. You have two charges at this point pending. The first charge is conspiracy to commit a crime. It's alleged that on or about November the 6th, you did conspire with an unknown person or persons listed as Really Good Pets LLC at 198 Opportunity Drive in Norman, Oklahoma, to commit the crime of trafficking a controlled substance, approximately 7 pounds of methamphetamine paste, subject to a United States parcel package being shipped to Quality Bulls LLC at 337 Mount Helm Road, Brandon, Mississippi. Am I under, Mr. Berry, under the understanding that the crime lab has returned a negative on that paste?
Your Honor, that's what I was just about to announce to the court. As to count one, which if we go and count this to the alleged methamphetamine, no controlled substance were found with that large amount of items, and so it does not appear, and I spoke with the investigator in that they plan to, if the court wasn't going to take it up this morning, remand it, but I see no other choice but to ask that count be dismissed at this point.
Okay. And I'm sure there's no objection, Mr. Sellers, to dismissing that charge?
No objection.
I will dismiss that charge. The second charge you had pending today was conspiracy to commit a crime. It's alleged that on about the same day you conspired with an unknown person or persons listed as Really Good Pets LLC at 198 Opportunity Drive, Norman, Oklahoma, to commit the crime of trafficking controlled substance, approximately 13 pounds of marijuana in a United States parcel package shipped to Quality Bulls LLC at 337 Mount Helm Road, Mississippi. I plead you not guilty on that charge. If you're convicted of that charge, the minimum is 0 years, maximum of 20 years. As to bond, the preset bond for that crime is $100,000. Does the state have any information they want to be heard on as it relates to that charge?
Your Honor, not at this time specifically. I think if we need to have a bond hearing, more information will become available. While obviously the preset bond was based on both of the counts, I still believe this is a very serious charge. 13 pounds of marijuana is a lot of marijuana and is a danger to our community. And so the state asks, I know that the preset bond in the county court is $100,000. I think that in light of one of those counts going away, I think it would be appropriate to reduce the bond in half to $250 in line with the court's previous understanding.
Mr. Sellers?
Yeah, I would just say respectfully, I don't know if there's a crime lab back on the marijuana substance that it could possibly appear to test as marijuana, but it could be a substance that's not marijuana. And so I don't think the bond should be at $250. I would also say I understand the state's position on marijuana. I would respectfully argue that it's also a substance that's legal in most states and also in certain settings legal in this state. So the fact that I don't think it has the same impact as a drug or a suspected drug like meth. So with that said, I think marijuana not being the type of drug that initially was thought to be involved, I think the preset bond that the court usually set for marijuana should be set at $100,000. With it being marijuana, I think there are a lot of conditions that the court can impose on Mr. Landers to ensure, one, the appearance when required. I think he's been cooperative at this point when he was arrested. He's a lifelong citizen of Brandon. He has military experience, 8 years of military experience. He's been an educator for 8 years. This is someone who's not a flight risk. I do think it's still an ongoing investigation where it may be determined. I have questions about the substance that was actually found, Your Honor. I think based on all those factors and the fact that we already have seen one charge that was dismissed based on it being overcharged is something that it wasn't. Would indicate that there's a possibility that there's room that this case may go in a different direction, in my opinion. But respectfully, I would ask the court to set a bond of at least $100,000. I think that's a substantial bond. Mr. Landers being an educator, he doesn't have extreme means to post a super high bond. $100,000 would be a bond that is reasonable based on all the circumstances. And with this being ongoing, I think he could possibly post that with help his family. I think there could be conditions in place. And it's not involving multiple people in this area, so it wouldn't be something that he would have to have limitations on contact with people. But I think any conditions that the court will put in place, Mr. Landers would be willing to abide by. But again, 34-year-old young man, never been in trouble, gainfully employed, lifelong resident. If we go down the list of things that the court should consider as far as holding bond, I think he's someone who's entitled to the preset bond of this county court.
But do you have any feel yet for if he bonds out his status or as a teacher or coach?
I don't, Your Honor, but I mean, just if I had to guess, I would assume that he would be on some type of leave from his job based on the charges. And I think that's another hardship of the consequence of being arrested for this. And he's prepared to deal with that, but also think he's someone who's capable of finding other gainful employment if that's a condition. So I assume that if he does not, or if he's not allowed to return as an educator, I do think he has the ability and capacity to find other employment and be a productive citizen while these charges are pending and we work through this process, Your Honor.
Thank you. Mr. Berry, you have a response?
Your Honor, I would just say that I guess part of the state's concern is, and I know it's not a specific bond guideline, Mr. Stillers did a great job of eloquently outlining that, but it is concerning that he is an educator. And while that's not a specific bond condition, but as just a practical matter of a member of the community, I believe that educators are held to a higher standard, and I think that this ought to be something that the court looks at when you look at bond.
Just brief response. He is an educator, but there's no allegation that he's selling to students or dealing with drugs to students or using drugs to students. And there's no, and for argument's sake, I know it's a large amount, 13 pounds, but could be a marijuana user that uses marijuana, just gets involved. I'm not saying that's the case. But what I'm saying is there's nothing in this investigation thus far that indicates that Mr. Landers is teaching school and selling drugs to students. I just don't want that implication put out there, and I don't think that's the facts of this case. He also is a student. He's in school trying to get his advanced degree at Belhaven. So, he's a productive young man. But to, I guess, associate this with him being a student, it'd be different if this was a sex crime and he had contact with students. That's not the case. It's a drug crime that there's no link between the alleged allegations of him not even possessing, because he didn't actually receive the drugs. It's just something that was sent and intercepted in the mail. The fact that that's the case, there's no separate indication. I don't think anyone can walk in this courtroom and tell Your Honor that, oh, well, we have evidence that he is also distributing to students or anybody that he works with. I don't think that's the case, so I respectfully ask the court not to even consider that argument. Just on the face of this case, I think it's something that's worthy of $100,000 bond.
Okay. All right. The first charge having been dismissed, we're left with the second charge, 13 pounds of marijuana. The Mississippi Rules of Criminal Procedure 8.2 have bond guidelines, and this is a crime punishable by 0 to 20 years, and under the guidelines punishable by a maximum of 10 years to 20 years. That bond is $10,000 to $100,000. I do think it's appropriate that it be on the upper end, or at the upper end. I am concerned with the quantity, and while I understand the argument of personal use, I find it a little hard to believe that 13 pounds would be ultimately for personal use. But I'm sensitive to the argument Mr. Sellers makes about the educator role he has. It's certainly not been an allegation at this point. I am concerned about that, but it's not an allegation and I'm not going to hold it against him because that's not been alleged in this case. But I am going to venture outside the bond guidelines on the singular charge. I'm going to set his bond at $150,000 a day, and I'll tell you, Mr. Landers, as part of your bond conditions, that you have to appear in court when required. If you bond out, you have to notify the court of any change of address or telephone number. You have to not commit any other crime while out on bond, not possess or be in the presence of weapons of any kind. You have to continue your employment if you're able to. You have to obtain an alcohol and drug assessment and comply with the recommendations. Not consume alcoholic beverages, illegal drugs and misuse prescription drugs. And you are a resident and without a prior record. I'm assuming Mr. Berry, he has no prior record.
I'm not aware of any, Your Honor.
Okay, I'm not going to require a GPS monitor. But listen, I just got to tell you, that's a serious charge. You're in a serious occupation. And we just got to be careful, but you got to listen to your lawyer. You got a great lawyer there. You need to listen to him. He'll keep you out of trouble here. But that will be the court from Mr. Landers. Anything else, Mr. Berry, from Mr. Landers?
No, sir, Your Honor.
Mr. Sullivan?
No, sir, thank you.
Thank you.